Ms. Sovell and Mr. Moore. I've got something to read here real quick, and then I'll administer an oath. Okay, so pursuant to Section 800, Subdivision 4 of the Masons Manual that governs House proceedings, in addition to House and Joint Rules, pursuant to House Rule 4-2, witnesses before a legislative body or its committee need not be sworn unless there's some rule or provision of law or of the Constitution requiring it. But witnesses give their testimony under the penalty of being adjudged guilty of contempt and punished if they testify falsely. While Mason's Manual does not require an oath, we will be asking each witness to take an oath to assure the committee that the witness's testimony is accurate. So if you please raise your right hand and repeat after me. I do swear or affirm.
I do swear or affirm
that the testimony I am about to give is the truth, the whole truth,
is the truth, the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
All right, thank you. Have a seat. If you'd please have you guys identify yourselves for the record.
Emily Sovell.
Michael Moore, I'm the State's Attorney in Beadle County.
Okay. Thank you so much. And Ms. Sovell, you are the State's Attorney in Hyde, is that correct?
I am the Deputy State's Attorney in Hyde County. I am the Sully County elected State's Attorney.
Okay. And thank you, both of you again, for being willing to come up and help us in your testimony here today. I will ask you and start this off with a question I've asked every entity regarding the investigation. At any time during your investigation or the process of your investigation, were you ever called or influenced in a way from the Attorney General's Office, Department of Criminal Investigations, or anything surrounding the Attorney General?
No, sir.
No.
Okay, thank you very much. Representative Stevens.
Thank you. Good afternoon. Thank you for coming and for your service to the state of South Dakota. It would be helpful to the committee, I think, if each of you could kind of give us a little bit of your legal background as to what you've been doing over the last few years.
I've been practicing law in South Dakota since 2001. I clerked for the South Dakota Supreme Court for 1 year after finishing law school at the University of South Dakota. I have had a private practice in Sully County for just over 20 years, and a part-time office in Hyde County for roughly 12 years. And I have been prosecutors in both Sully County and in Hyde County for over 10 years.
Thank you. Mr. Moore.
I've been the full-time State's Attorney in Beadle County since 1997. Prior to that, I was Deputy State's Attorney for a few years. I prosecuted cases primarily in Beadle County, but on occasion I do prosecute cases for other prosecutors in other counties across the state.
Thank you. We'll start with Ms. Lovell. Can you kind of tell us, the committee, a little bit how this all came to your attention and what your activities were once you found out that there had been a death?
I was initially notified by the Hyde County Sheriff, Mike Volek, that there had been an accident involving the Attorney General. There were some discussions with him throughout the day following the accident, and he had notified me that outside law enforcement agencies were being brought in. That was all underway by the time I was fully apprised of what was developing.
And tell me, what was your process as far as having such a case of a lot of notoriety, how you were handling the information that was coming in, and what information you felt you needed in order to determine your job as State's Attorney?
Can I have you bring your mic just a little bit closer?
Yes,
So
yes,
it's
sir. Well, it was a challenge. This was a case with a tremendous amount of public inquiry, a lot of calls, a lot of media inquiries, and we have a very small office, so I did my very best to sort through what was coming in. I worked directly with the law enforcement officers that were on the ground as soon as I was able to identify who was the lead, primarily with the Bureau of Criminal Investigation of North Dakota, and started to develop that relationship with them so I knew who I could contact and work with.
Okay. And what input did you have into the investigation at all?
I don't know that I would say I had input. Certainly I would ask questions, but I let the officers who knew what they were doing do their job. And if I had questions or if I had something that I needed to have done, I would notify the appropriate individual.
And did you receive any support or information from the South Dakota Department of Public Safety?
Did I receive information from them?
Yes.
Certainly.
Okay. And were they involved at all in the process as far as helping you do your work?
Well, the South Dakota Highway Patrol officers that were on the ground doing the accident reconstruction were an integral part of the investigation. I worked mostly with the reconstructionists who were on the ground.
Okay. And were there ever times where there were meetings with representatives from the Department of Public Safety?
Yes.
And tell us a little bit about that. How'd that come about?
There were some meetings that I had set up. There were some that were requested from Secretary Price and others within the Highway Patrol.
And were there other individuals that are involved in these committee meetings besides you and the Department of Public Safety? Or, I mean, was it a collection of other people, or was it just with them?
There were some that were just with them. There were some with prosecutors. As you well know, I had a team of prosecutors put together to assist with all of the evidence that was coming in. Some of them were group meetings, and some of them were with me and either one or some of the reconstructionists, highway patrolmen, Bureau of Criminal Investigation.
Okay. And what was the purpose of having these different groups?
To have them apprise me of what was going on, for me to ask them questions, to simply keep us up to speed as the investigation progressed.
Okay. And so when you're looking at this, the set of facts and trying to determine whether charges needed to be brought, can we kind of go through the different, and certainly, Mr. Moore, you can add in when it's appropriate and be helpful. That's not a problem. So if I ask the question, either one of you can flip a coin as to who's going to answer the question. But can you kind of go through from a legal standpoint as a state's attorney, you know, what you felt after you received all of the information? And I'm understanding it's what we've seen has been a voluminous amount of information, particularly with, you know, the type of cases maybe that, you know, you might have not had in the past with the notoriety and everything. Can you kind of give us an outline of, you know, what the options were that you were looking at to try to determine how to proceed?
Well, as you well know, it took quite some time for all of the material to process and come to the table for us to assess as a whole. Just like in any case, once you have all those reports in, you lay out the potential crimes that may be at issue, and you start looking at the elements of those crimes, and you start applying the facts that you have before you.
Can you give us, the committee, a little bit of an idea of the totality of the amount of information that you received from all the different investigators and law enforcement that you had to go through?
I had hard drives. I had boxes. It was one of the largest, most voluminous investigations I've seen.
And you had other work to do too, I suppose?
Yes, sir.
Okay. So if you could go through with the legal options that the state of South Dakota has available, and go through kind of you and Mr. Moore's and whoever helped you in that regard. If you could go through that, that would be very helpful to the committee.
I had, we as a group of prosecutors had the opportunity to sit down with the accident reconstructionist to assess the scene, to look at the videos, to look at the reports. We had the opportunity to sit down with the investigators from North Dakota to walk through all of the interviews, to do a play-by-play essentially from the beginning of what happened the day prior to the accident involving the Attorney General until the final input of the last piece of evidence that was analyzed in the lab. And we then looked at all of the potentials, including everything from the vehicular homicide through the potential manslaughters to the misdemeanors that were ultimately charged, and just did as you always do, determine if the facts fit the crimes.
And it was, as it relates to vehicular homicide, and Mr. Moore, you can add in, like I said, whenever you want to as well. Why was that, you did not feel that that was applicable?
Vehicle homicide in this case was not applicable because it requires the driver or the defendant to be under the influence of alcohol or drugs or something like that. It also requires negligent driving, but in this case, the investigation indicated to us that the Attorney General was not under the influence of alcohol or any drugs at the time of the accident.
And what information or facts were you rely upon to come to that conclusion?
Because there was no drug test because of what happened at the crime scene, so it was an investigation. They did a timeline about where the Attorney General was that night, who he was with, and they did numerous interviews to talk to people. They also were able to trace him from where he was at in Redfield all the way to the time of the impact. There was video of his vehicle, so they knew that he hadn't stopped anywhere from Redfield to where he hit Mr. Beaver. So that was basically the investigation, but we relied on what the individuals, where he was at in Redfield, what they told the investigators.
Okay, well, what about manslaughter in the second degree?
Manslaughter in the second degree requires recklessness. So you have to prove that there was a death cause and that the person causing the death acted recklessly. So we basically went through that, you know, and there's case law on that in the state of South Dakota, and I think everybody's been provided with what the Supreme Court has said about that. But basically, you're looking for a person that knows of the risk and disregards it. So in this case, that's what we were looking for. What happened? What were the facts that we were able to determine to indicate what happened when the impact happened? And obviously, we had the facts that indicated that he was outside the lane of travel, but we weren't able to determine why he was outside the lane of travel, how long he had been outside the lane of travel. They were able to determine his speed, which was, I think, 2 miles an hour above the speed limit at the time of the impact, but they weren't able to determine why he was outside the lane of travel. And what I do in trying to establish that they knew of the risk and they disregarded it without knowing that, I don't believe it amounted to a reckless act, and that's why manslaughter was not charged.
Well, what information would you have needed to have in order to overcome that hurdle, I guess, from your standpoint?
And I can give you an example. I've prosecuted many of these cases or not many, but I've been prosecuted 2 cases of this type in my career, and I've declined prosecution on probably 3 or 4 were the facts. So the ones that I did prosecute, it was a person that went through a stop sign at highway speed. That person was texting at the time, so we also were able, through the highway patrol and the accident reconstruction, that person missed 3 indications that there was a stop sign ahead, and that they were on their phone at the time, and they went right through the stop sign and struck a vehicle and killed the driver of the vehicle. And we prosecuted that person for manslaughter. In the other case, it was a semi-truck that was being operated without, it had 1 working brake. And again, that would seem reckless in and of itself, but the problem in that case was we had to establish that the person knew that there was only 1 working brake on the vehicle. So the investigation in that case entailed us going back and trying to determine if they had the vehicle checked, how would a person know that the brakes aren't working, did the operator know the brakes weren't working, and in that case we were able to determine that there was evidence of that through witnesses' testimony, and we proceeded with the prosecution. In this case, there wasn't anything like that. There was the only fact that we had at the time was that the Attorney General was outside the lane of travel, and he wasn't on his phone at the time. And we thought that he may have been on his phone. He was on his phone previous to the accident, but I think it was about 1 minute and 15 seconds. His phone was locked before the impact. So at the time of the impact, he was not on his phone. And in the interviews with him, he doesn't really give a good explanation of why he's outside the lane. He indicates that he didn't know he was outside the lane. And I believe that without being able to establish that beyond a reasonable doubt at trial, we could not gain a conviction for manslaughter.
Okay. There's been some questions as to why this matter wasn't brought before a grand jury to decide. Can you help the committee a little bit understand that decision?
Certainly. Grand juries are bodies that are brought together to establish whether or not there's probable cause, enough probable cause to proceed with your investigation and your charges. At the point when we had a plethora of evidence, we had, as I said, hard drives of evidence. This wasn't a question to toss out to say, is there probable cause or not? We had everything we needed to assess the case as a whole. I typically use grand juries if it's earlier on where we don't have everything in, we have someone in custody, there's some timetables that are running, and we need to have that probable cause established to continue proceeding with the case. I know other prosecutors treat them differently. They used them more as standard course. But in this case, this wasn't a question of just probable cause. It was time to make the charging decision as to what could be proven beyond a reasonable doubt. That's what our requirement is.
Right, and I would agree with that. You know, this was a legal determination that was made, and passing that buck off to 10 individuals from the community that have no legal background to ask them to interpret the law and determine what the law is, and that's why we went to law school. That's why we passed the bar exam. That's why we're the lawyers. I'm the elected state's attorney. We're tasked with making those decisions. So it wasn't a factual issue. Everybody agreed what the facts were. It was a legal determination that it didn't amount to manslaughter. So you don't present that type of case, in my opinion, to a grand jury, because the grand jury isn't educated enough or trained enough to make a legal determination. That should be made by lawyers and judges.
And what about, can you give us a little bit of history, I guess, as it relates to negligent homicide?
A lot of states do have negligent homicide. I think I pointed out in my press conference, I really didn't do a lot of research on it prior to this case, but there is no negligent homicide in South Dakota. I believe Justice Henderson, in a opinion that he wrote, I think it was an opinion that he wrote regarding a manslaughter case on a traffic accident, he mentioned that there is a big gap in South Dakota between carelessness and recklessness, that there's no negligent homicide, and he cautioned the legislature in filling that hole and whether you really want to do that. Well, the legislature took him up on that, I think, in 2006, and there was a negligent homicide bill presented to the legislature, and the legislature declined to enact that as law. But the one thing I noted in my comments is that if you read that bill in 2006, that it specifically excluded traffic accidents as a grounds to charge negligent homicide. So that's at least my understanding of the history in South Dakota. I don't know if it's been brought up since 2006, but right now we're limited in obviously prosecuting the laws that the legislature passes, and in South Dakota we don't have a criminal negligent homicide statute.
So in your opinion, there wasn't any other options as far as bringing charges based upon the facts that you had in front of you?
Not as it relates to the death of Mr. Beaver.
Okay.
So there was criminal charges that we brought under Class 2 misdemeanors for the driving infractions, but to get to the amount where you're criminally responsible for the death of another person, you have to establish that it's manslaughter, murder, vehicle homicide, and we didn't have that.
Now, you indicated that you had the groups that you were consulting, like with the Department of Public Safety. How did those things go? How did that work?
Well, a lot of the meetings, they varied, really. Sometimes it was me calling in a Trooper Burnt who was doing a play-by-play at the accident scene and sitting down at the conference table in my office to show me the trend lines, to show me the drone footage, to walk me through the accident scene. Other times it was phone consults. We had full group meeting at least one time with the team of prosecutors and a number of members from both North Dakota and from the South Dakota Highway Patrol, and to just review the evidence and discuss potential options.
Well, you must have been under a lot of pressure with this case.
There was a lot of pressure in this case.
And was there a period of time that you felt that you were getting unduly influenced or pressure put on you to make decisions prematurely?
I will assure this committee that I excluded any person or any party that was trying to unduly influence my decision with respect to this case.
And did you have to do that?
I did.
Okay. Now, you know, throughout this, we have this situation where, you know, I think all of us have seen on TV or otherwise where, you know, when something has happened, you often see the state's attorney, or down like in Nebraska, it's county attorney or whomever it might be, even attorney generals. When there's an investigation on, you always hear, well, we can't talk about this ongoing investigation. And could you tell me why people say that?
Well, our laws and our system is set up to protect the integrity of the investigation. We have, whether it's the open meeting rules or the ability to seal your search warrants, we need a safe process for investigators, for law enforcement, for prosecutors to assess what happened without being a play-by-play in the public eye, so that you can avoid interference from a lot of that outside noise or concern or obstruction, those types of things.
And would you not also agree with me that the purpose of doing that is also to provide due process to a person who may be at the heart of the investigation?
Absolutely. It makes it extraordinarily difficult to go in and find a jury that hasn't been influenced, to ensure that the process for both sides is fairly played out. We have due process.
Okay. So it's really sent to protect society as well as the individual and their constitutional rights.
Yes.
Now, in this instance here, that was not done, was it?
This was very different, and it was a very different investigation for me. I understand that there was public interest because of the fact that it involved the Attorney General, but I still deemed it extraordinarily important to preserve the integrity of the investigation so we could do our job.
Well, did you have conversations or communication with the Department of Public Safety where you gave them permission to release videos or any other information prior to filing charges against the Attorney General?
There were many inquiries to release things early on, and I resisted. I think there was finally a point of discussion where the requests from media, from the outside, from Department of Public Safety had been numerous enough that I authorized, I believe, the 911 audio as well as maybe the preliminary crash report. I would have to go back and look, but I did give my blessing at least on a couple of those preliminary things.
Well, what about the interviews that were released?
Absolutely not.
Okay, did you send a message or communicate text-wise or otherwise to the Department of Public Safety asking them not to release that information?
I did. I had, I believe the day of, or the day prior, I had learned that there was a planned press release with discussion about the release of those, and I sent an inquiry, or I sent an email actually to Secretary Price and to the investigators involved, stating my concern and requesting that they not be released.
And why would you not want that to be released?
Because these are investigative records that are not, that are records except from the open meetings requirements. The case was still ongoing. We hadn't had an arraignment. It was certainly not within the norm of any case I had been involved with, and it's something that our Supreme Court has helped us to protect, to prevent this from coming out for purview.
Did it make it harder for you to do your job when information like that is released without your permission?
Yes.
Mr. Moore, have you had any situations like that before that haven't occurred to you, considering the number of years that you've been a prosecutor?
No, I've never been involved in a case where the interview of the defendant has been released to the press, I think, at all, and especially while the case is pending. And that's clear. I mean, the big I mean, it's an ethical violation for me as a prosecutor. Even though it was done by another party, that's my case, and I could be disciplined for that happening, and the evidence could be suppressed. I mean, there's all kinds of ramifications that could happen if evidence like that is released to the public prior to the case being resolved, because it can taint the jury, and it could negatively impact the ability to prosecute the case. And so that has never happened to me in my career as a prosecutor, that an interview of the defendant has been released prior to the case being over.
Can either one of you think of any benefit that would help you as prosecutors, or for someone who's being accused to have that information released prematurely?
There would be no benefit to us, no.
No, sir.
Okay. In your handling of this case, and I'll ask that to both of you, was the Attorney General's case handled any differently than you would have anybody else's?
I assess the facts and the law the same way I would in any case. It was certainly different in the voluminous materials and the public interest in it, but I handled it the same as I would any other case.
Mr. Moore?
Yeah. I would say the same thing. I handled it like any other case, and it was obviously a high-profile case. I've been involved in other high-profile cases. I've had meetings with law enforcement during those cases. We talk about the investigation. So this case was no different in that manner.
Have you ever had a case similar to this where there was that much investigation done?
I wish I could say I had, but I've done homicide cases, and they haven't been investigated as thoroughly as this case. I mean, I was impressed with the investigation. I thought North Dakota did an excellent job of getting us that information. They did a thorough reconstruction by the Highway Patrol. I was very impressed by their investigation, and I would take that investigation in any of my cases. I mean, it was second to none.
Same with you?
I agree. It was extraordinarily thorough. The work, the man hours, the time, the energy that went in from the North Dakota agents, as well as the gentlemen that were out doing that accident reconstruction. It was incredible.
Okay, was there any information that you felt that you needed that they didn't provide you?
No, sir.
Mr. Moore?
No. And I would just say, as the process went, there was times where I thought we were asking for additional things that were probably not really needed, but you just wanted to make sure. You just wanted to cover all your bases in a case like this. So they did an excellent job, and I don't think there was anything that we left unturned.
So the bases were covered?
Yes.
Yes.
Thank you. I have no further questions.
Thank you. Further questions? Representative Schwab.
We previously met with two of the investigators. Thank you for being here. Thank you, Mr. Chair. We met with two of the investigators, and they both reached they said to us under oath that it was their opinion that the Attorney General was lying to them about whether or not he knew he hit a person at the time. Did they ever express that opinion to you during the course of your investigation?
Yes, sir. I believe that was part of our discussion.
What steps were taken then to try and firm up if the Attorney General was telling the truth or not in the investigation?
The prosecutors reviewed all of the interviews. There were a number of interviews.
Could you bring your mic just a little bit? I'm sorry. No, that's okay.
There were a number of interviews that were conducted. All of those were watched and rewatched and assessed and analyzed, and I understood their concerns. I could hear and see some of the areas that they were expressing concern about, but the reality is the areas where they were expressing concern didn't validate or justify an additional criminal charge of any sort. There was nothing where the elements of a crime fit where their areas of concern were expressed.
Well, I just want to understand, because, I mean, what they said was the lie was about him being on the side of the road, and then whether or not he hit a person at the time when he knew it. Which both of those, if he's lying, I mean, could lead to, I mean, failure to report could be a charge there. I'm just curious, when you say you didn't know, we don't know the reason why, and here the investigators are saying, well, to the question of why, we don't believe he's being truthful, what steps were taken to satisfy that concern of the investigators who just did a very thorough job, that he wasn't lying?
Well, sir, I'm not sure what additional steps they could have taken. An interview is an interview. The individual said what he said, and outside of interviewing again and again, which they did, there's no other way to prove that.
It's just under oath, right?
Correct.
The witness being under oath could prove that.
Potentially.
Yeah. Following in the press, I know there were multiple other prosecutors involved besides you two. Who else was involved?
The original team that came together was Crystal Johnson out of Minnehaha County, Mark Fargo out of Pennington County, Michael Moore, and myself.
Okay. And when you say the original team, were they the team that went from the beginning all the way till the time of a plea agreement being reached?
All of the prosecutors remained active until, I believe it was the January prior. Crystal Johnson was needed for some additional demands in her office, and she was no longer able to assist. She was wonderful and was a great addition while she was there, but she just had a lot going on in her office and had to step aside. Mr. Vargo was there through the charging decisions.
Okay. Did Mr. Vargo agree with the charging decision?
That's a question you'll have to ask Mr. Vargo.
Okay. He didn't tell you?
We had a lot of discussions about the pros and cons of all the charges.
Okay. But he didn't tell you if he agreed with your charging decision or not?
I don't know if I asked.
Okay.
At the end of the day, the difficult part for me is that was my jurisdiction and it fell on my shoulders.
I know you said you didn't ask. Did he tell you what his thoughts were?
We shared a lot of thoughts throughout the process. We did a lot of devil's advocate of what about this scenario, what about that scenario, and at the end of the day, if you want to know what Mr. Vargo thought, I encourage you to.
You won't
visit
answer
Mr.
that?
Vargo. No, sir.
Okay. No further questions.
Further questions? Representative Vanson.
Thank you, Mr. Chairman. Thank you both for being here. Ms. Sovell, earlier you had indicated that you felt like you were unduly influenced during the course of your investigation. I wonder if you could say by who and what the nature of the undue influence was.
I'm not sure that I said I was unduly influenced, and if I did, I'll correct. I took careful effort to make sure that nobody was going to influence me from a political standpoint or from anything outside of the evidence that I was reviewing.
Okay, maybe your answer then, and this is regarding Representative Stevens' line of questioning, that there was attempts to unduly influence the investigation.
Sir, I'm not even sure if there was an intent. My caution was if I felt that there was any political nature or anything of concern coming in, I took the steps to keep it out.
Okay, did you feel pressured by people outside of the investigation to make any particular charging decision?
I did not allow anyone to pressure me into a particular decision outside of the evidence and the laws that I was assessing.
Okay. Were there attempts to pressure you?
I don't know what their intent was. There was a lot of inquiry and requests to release evidence, and I did not succumb to that.
And I would just speak to that. I mean, in a case like this, you always feel there's always pressure, whether it's undue influence or whatever. I mean, it was clear to us what the Highway Patrol's opinion was. I mean, they wanted him charged with. I mean, that was clear. I mean, I think Colonel Price wrote that in his letter. So we knew that going in, but that's not, I wouldn't consider that an undue influence or anything. I mean, law enforcement and prosecutors disagree on things. I mean, so, and I thought we had productive conversation. I had personal conversation with Mr. Price about why I felt the way I felt and why I made the decision that I made. In this case, that ultimately Emily made. But I wouldn't consider that, and it was clear to us. I mean, we don't live in a vacuum. We know what the governor wanted us to do. I mean, but it's not any different than, that's what I try to say. In a murder case, I have victims. They want me to charge somebody. They want someone held responsible. And I've been doing that for 20+ years. So in this case, it's not any different for me in that respect, other than the people doing it obviously are more known than if it's a victim in Beadle County that had a family member murdered. But I think the pressure is the same, but that doesn't influence the decision, because ultimately we have to make a decision based on what the law is. And and at least in my experience, and I think with Emily and my part of the process, and to go back to the question they did, the prosecutors were supportive of the decision that Emily made. She was given the information, and it was ultimately her decision, and everybody on the team was supportive of that.
Was there anybody associated with the Attorney General that tried to influence your decision one way or the other?
No, sir.
No, I never had any conversations about this case with anybody from the Attorney General's office.
Okay. Where do you, you can answer this individually, where do you believe the Attorney General was at on the road at the time of impact?
The reconstruction reports and the information that's presented to us was that the point of impact was outside of the lane of travel on the north side of the highway.
Mr. Moore?
I agree with that. You know, how far outside the lane of travel, I think, would have been up for debate. I think that the Highway Patrol would say both wheels were outside the lane of travel. I've done enough of these cases where you have experts talking about that, and I was confident that the Attorney General was outside the lane of travel, but how far outside the lane of travel, I think, would have been fluctuated depending on if you had a trial on that, if someone had to make a determination. I would say outside the lane of travel, but the distance, I was not confident that he was 9 feet, but I was confident he was outside the lane of travel.
So we heard from investigators, and they seemed pretty confident that the Attorney General was completely on the shoulder of the road, all 4 tires, outside the lane of travel at the time of impact. What makes you think that that might not be accurate?
Well, I just say, based on my experience, and again, you're relying on expert testimony based on where evidence is, and based on what I know and what other, when I've done other reconstructions, there's a margin of error, and there was fragments that could have been placed him closer to in the lane of travel. So, and again, our determination wasn't definitive on whether he was outside the lane of travel or not, because, like I said, we have to know why, because that gives us reckless. So it was really immaterial to me how far outside the lane of travel he was, unless we knew why. And so, and experts are supposed to be, confident in their opinions, but I've done this enough to know that when you go to trial, I have to know what I think I can prove beyond a reasonable doubt. And in this case, I think I could prove beyond a reasonable doubt he was outside the lane of travel, and I would have left it at that.
We also heard from some investigators that because of where the AG was positioned on the road, that he was obviously distracted. I just invite you to comment on that. If you were, I guess, on a couple of fronts, do you think that it's obvious that he was distracted in this event, and how does that play into bringing a charge where you have to prove recklessness?
Well, I guess I don't agree with the fact that he was obviously distracted. I mean, people drive outside the lane for a variety of different reasons. And it doesn't mean they're distracted. If you look to the right and you go outside the lane, you hit the rumble strips, you come back. At the speed he was traveling, he was going, I think it was 98 or 97 feet a second. So when you think you're going outside the lane and you hit that rumble strip, you come right back. Well, you've traveled a great distance in that time. So to conclude that he was obviously distracted, I don't think is a fair assessment of, because we just don't know that. You could look away, you could have dropped something, he could have been looking something else. Just without knowing that, the lane merges prior to that where it happened, and maybe he didn't move back over to the left. I mean, these are things that I would have had to combat if it went to trial, because there would have been a million reasons he could have been outside the lane of travel that wouldn't have indicated that he was distracted. And if I can't prove that, it's not reckless. And you have to be able to establish that they knew the risk, and they did. And I would say, how many people drive outside the lane of travel and get a ticket for reckless driving? I mean, I've been prosecuting 25, 30 years, and I've never seen that. So just outside the lane of travel itself isn't enough. So those are the kind of the things that went through my mind. And something happened that he went outside the lane of travel, but did that equal reckless? Did that equal distracted? I don't agree with that. People go outside the lane of travel all the time, and we're certainly not prosecuting them for reckless driving.
Thank you. No further questions at this time.
Representative Hogard.
Thank you, Mr. Chair. Was part of your charging decision, this is for both of you, did part of the decision focus around the fact that this accident scene was not protected for, I think, 10 or 11 hours, something like that?
There were discussions about the potential changes, about wind, about weather, about traffic patterns. It was certainly discussed, and it was certainly something that we knew we were going to have to deal with. But the reconstructionist's opinion was that it was not a significant change to the trend lines and the evidence that was on the roadway.
All right. This has been a little bit puzzling, for me at least, that in the press it's always indicated that North Dakota handled this whole investigation, and then when it came time for us to look through some of the evidence and hear some of the people testify, it sounded as though South Dakota was fairly significantly involved in this. Can you expand on that?
North Dakota did the investigative work with respect to the interviews and the processing of all of the materials and compiling them for release to my office. South Dakota Highway Patrol was in charge of the accident reconstruction portion of it.
So that kind of leads me to this question about who specifically was contacting you, trying to influence you in the direction of a different charging decision.
Again, I don't think that I testified that anybody was trying to influence the charging decision. I felt a lot of pressure with respect to release of the evidence that caused me concern. So I used my primary point of contacts on questions regarding the investigation, the interviews, the overall assessment of the case. I spoke a lot with Arnie Rummel, with Joe Ahrens out of North Dakota office. When it came to accident reconstruction questions, I had a number of discussions with the Aberdeen office, the South Dakota Highway Patrol. Primarily, I would say, primarily Trooper Burnt.
All right, and then back to the question of, I think you said something to the effect that if you felt or were starting to feel undue pressure, you excluded those individuals from your communications, I guess. Who was it that you excluded from your communications?
Secretary Price.
Did he indicate to you why he was communicating with you specifically? Did he indicate that this was solely himself, or was there someone else involved?
I believe his desire for release was pegged towards the declaration that they were going to make this transparent because of the involvement of the Attorney General. I know that was part of Governor Noem's press release. I don't know that he specifically said that it was from Governor Noem, but I was aware that there was a desire for transparency.
Well, and along that line, then, the idea of transparency, did you discuss, at least early on with Secretary Price, that there's a difference between transparency and actually trying a case?
I believe I did discuss those concerns with him.
And what was his response?
There was a very strong desire to have the evidence out to the public because of the need for transparency, and I disagreed with that.
You mentioned that the information, the investigation, it was voluminous. In your experience, as you present cases to a jury, do you find that a variety of things influence a juror's decision as far as details?
Certainly, jurors are human beings, and they grasp onto different things, different details. Yes.
And I'm just wondering, were there any lawmakers that ever contacted you about this case, about charging or anything related to the case?
No lawmakers contact me with respect to charging or encouraging charges one way or the other.
And Mr. Moore, anyone contact you from
Not,
lawmakers?
no, not regarding any of the facts or any charging decisions or what was happening. I did talk to a senator about timing, about when we were going to do the press release, but that was the only conversation I ever had with a lawmaker about it. But it was not related to any facts, and he didn't ask me any questions about the case other than what's the press conference going to go on at the time that it was about a year ago this month.
As you were proceeding along in those early days, I'm trying to recall if that was in the first week, 10 days, was that when the pressure was kind of on for releasing information, or how far into this did it go?
There was some early on, and it persisted for a period of time. I would have to go back and look to see. A lot of that was early on, though, sir.
Did you then join with the defense attorneys in regard to trying to limit the release of information?
There was no discussion with defense attorneys until after the charging decisions were made, and they had motioned the court themselves. I believe in that motion they cited the fact that I had requested that the investigative materials not be released by the Department of Public Safety.
And do you recall when you decided that you needed to make more of a demand upon Secretary Price to not release information? Was that on the heels of his statements to you that he was going to?
No, sir. It was. I would have to go back and look to see when those communications occurred. But there came a point after the evidence was being processed where the waters calmed somewhat, the releases were less, and I think it was at that point that I had. I believe that was at the point where I had said that I was not going to include him in some of the conversations because I didn't want there to be any appearance of any political pressures or anything from the outside to make the decision in this case. I don't know how far that was in.
But you did send emails to his office to express your concern about release of information?
I believe there was an email, at least one. Most of my communications with him were by phone.
And in the midst of that, did you contact the governor's office at all?
No, sir.
Okay. And Mr. Moore, you'd indicated you understood there was public pressure along that line. Did you communicate anything to the governor's office?
No, I never had any contact with the governor's office.
No further questions.
Thank you. Further questions? Representative Jensen.
I believe, Mr. Moore, you mentioned, and maybe I've missed this through the whole thing, that there, and I just looked at Google Maps, there is a turning lane as you come out of Highmore, because you mentioned merging back in on the lane. I'm not familiar with the town, but Google Maps, I can see that merging lane. How far from where that ends to the point of impact? Would you just get, I mean, is it a quarter mile, is it a half mile, is it 100 yards? Just, I know you're not the investigator, so I know it's a guess, but.
Yeah, and we did do these, we had the investigators, when we had our meetings, do that measurement. And I don't want you to hold me to anything, but I would say it was over 1,000 feet. It was probably looking at about a quarter of a mile or so. So maybe 2,000 feet or something from that merge lane in. And one of the things that we also did on that is that the surface remained pretty similar, pretty constant. So, but there was a white line there, so if you were driving, you would have seen the white line on your left. But so there was a painted white line there. So those are things that we talked about in that. But that was, I think it was about 2,000 feet or 1,500 feet.
So just one follow-up on that. At the point where they merge, is the rumble strip there? Would it be possible to get onto that shoulder without hitting the rumble strip? I guess my point.
Yeah. So if you would keep driving straight when the lane merges to the left, you would be to the right of the rumble strip. So you wouldn't hit the rumble strips. Don't start until after the lane actually is back into a regular lane.
Okay. Thank.
Representative Barthel.
Thank you, Mr. Chair. And thank you both for being here. I'm sure you might think differently, but you're not on trial here. We're just trying to answer some questions on how you came to the conclusions that you did and what it all takes to make a charging decision. And believe me, I can appreciate what all went into that. So he was charged with 2 misdemeanors, and so the one was the use of the electronic device while driving. So was that based on his activity with the phone prior to the impact? Because we knew the phone was locked at the time of impact. Is that right?
Yes, sir. There was actually 3 charges originally, and the one with respect to the electronic device was for the phone activity east of Highmore.
Okay, thank you. And so then another charge was for deviating or traveling outside of his lane, and so was that for the when he was outside of his lane at the time of impact?
Yes, sir.
Okay, thank you. And so it was mentioned we don't have a negligent homicide law with the vehicle in our state. If we had, do you think what he did would have fit that charge?
It would depend on how that statute was drafted, but potentially if it encompassed the activity that occurred.
If the version was passed in 2006, it would not, because it specifically excluded traffic violations as a grounds to reach negligence. But other states' negligent or criminally negligent homicide statutes, if it was drafted similar to other states, it could fit as negligence.
Thank you. That's all I have.
Further questions? Further questions? Representative Haugaard.
Yeah, just to clarify, I think the public even yet still blurs the line of the electronic device. The Attorney General entered no contest pleas, correct?
That is correct.
And so that's not an admission of guilt, that's just simply not contesting the charge. Is that correct?
Correct. The court treats him essentially as a guilty plea with respect to how the conviction goes in the record, but the plea is no contest.
And the electronic device charge, that was completely unrelated to the actual impact?
Correct.
Okay. And just going back to, you made reference to some senator contacted you. Who was that?
I think that was me, and it was Senator Wheeler. He's from my district. He's an attorney in my district, but it wasn't. He heard that there was going to be a press, I don't know what we called it, a press release or something, or a press conference, and he just asked when it was and where it was going to be. So but we didn't discuss the case at all. But I think, just to be totally clear, I did have a conversation with Senator Wheeler, just that we were going to do this press conference.
And Sovell, anyone else contact you?
Nobody to discuss the actual charging decisions. I had an inquiry on timing from Mr. Schoenbeck.
And was that about the same time frame?
It was some time before the press release. I can't tell you exactly when it was. And it was just basically when will the decision and the charging decisions be made.
All right. All right, thank you.
Further questions? Okay, well, thank you very, very much. Again, we appreciate your willingness to come here and help us out and answer our questions. So we really appreciate you being here. Thank you.